I mean, it's a havoc. My client has not lived in their home as a result of this for the last 3 years. She was forced to leave her home, resulting in her depression.
This is case number 220113780, Joan Taylor et al. Versus Carpet Deluxe Inc.
Counsel, appearances for the record.
Tom Croft for the plaintiff, Your Honor.
Good afternoon, Your Honor. My name is John Mooney. I'm appearing on behalf of defendant Carpet Deluxe.
Okay, thank you. And Mr. Mooney, this is Carpet Deluxe motion for summary disposition. You may proceed.
Thank you, Your Honor. I will try to be as brief as I can. The basic factual underlying situation in this case is that the plaintiff hired defendant Carpet Deluxe to do some home repairs and some renovations in her house after some damage. The defendant Carpet Deluxe then hired co-defendant Soto to actually do these home repairs. Now, we understand that the issue of whether or not co-defendant Soto is an employee or an independent contractor has already been decided by this court. We are not intending to argue that today. At trial, we're not going to concede it, but we're not going to argue that today.
Thank you.
The basic underlying case is that the plaintiff alleges that there is personal injury and property damage caused by co-defendant Soto, which is therefore attributable to defendant Carpet Deluxe. The plaintiff alleges she was injured by some sort of product that the defendant Soto brought into and worked with in her home. The plaintiff alleges that this was some sort of self-leveling floor mixture. However, there is absolutely no identification of what this product actually is. There's no brand name, there's no manufacturer's name, there's no trade name, there's no identification of an actual product. There's no evidence as to what was in this product that defendant Soto worked with. And there is no evidence of any injury that could have been caused by this quote unquote product. Now, we understand that this is a motion for summary disposition, and we have to take all the evidence in the light most favorable to the plaintiff. We understand that the plaintiff has produced evidence that there was silica in the plaintiff's home. Again, Carpet Deluxe will dispute this at trial, but we understand for purposes of this motion that we have to look at the facts, the evidence that way. We also will dispute the sufficiency of the testing at trial. But again, that's beyond what we're doing today. While there is evidence that there was silica in the plaintiff's home, there is no evidence that the silica came from this quote unquote product. There is evidence in the record of other sources of silica. There was concrete cement that was already in the plaintiff's home that was removed. There was jackhammering of cement in the plaintiff's home. There are other potential sources of silica, and there is no evidence that this silica came from this product. Also, there is no evidence of the amount of exposure to the injured plaintiff from this quote unquote product. There is no evidence as to whether or not the exposure to silica was sufficient to cause disease. The plaintiff's argument in a nutshell is that she was breathing something in the house. There is no evidence of any respiratory disease. There is no evidence of what the size of anything that she was breathing in her house was. In order to get injury from breathing silica, you have to breathe silica. There is no evidence that the size of the particulates that the plaintiff was exposed to were of the size that could have made it through her nostrils, through her nose hair, down her trachea, and into her lungs. There is simply no evidence presented by the plaintiff that this happened. Therefore, Defendant Carpet Deluxe is asking that this case be dismissed because there is no evidence of what this product was, and there's no evidence of any injury that was caused by this unnamed product. Finally, Your Honor, the plaintiff has alleged that she has produced sufficient evidence of silica in the house, that she breathed it, and she was therefore injured. Again, we do not believe that this is sufficient to pass any legal or factual standard. The plaintiff alleges that there is an expert report that the silica use did not align with the recommendations of the manufacturer. And again, I question plainly with common sense, how can you make a claim that the manufacturer's recommendations weren't followed when we have no manufacturer? We have no identification of what the product is. The plaintiff relies heavily on the Powell-Murphy case. The name is very long, so I'll just refer to it as Powell-Murphy. That circumstantial evidence in a toxic torm claim is sufficient to pass summary disposition. The entire ruling in the Powell-Murphy case also goes on to state that without evidence of the dose and of the exposure of that claim, it's not sufficient to pass summary disposition. The better example is the Lowry case, which Powell-Murphy relies on heavily in reaching its decision. In the Lowry case, there was an oil spill into the Kalamazoo River. The plaintiff's basic claim was she wasn't sick before the oil spill. There was an oil spill, and afterwards she was sick. There is no evidence in the Lowry case as to what toxin was spilled into the river, what toxin the plaintiff was exposed to, and therefore what toxin caused the injury. That's exactly what happened in our case, and therefore we believe that this case law is controlling. So in a nutshell, there is no evidence of what product the plaintiff was exposed to. There is no evidence of the dose of the toxin that the plaintiff was exposed to. There is no evidence of any injury caused by this alleged exposure. And therefore, Your Honor, we believe that this case should be dismissed on summary disposition. And I thank you for your time.
Thank you, Mr. Mooney. Mr. Carl?
All right, so, Your Honor, I thought that was going to be brief, but here's my response. Essentially, my client was symptomatic as a result of exposure to crystalline silica, symptomatic in that she had troubles breathing, she was, coughing, etc. They tested the particles that were in her home, thoroughly tested it. They had determined whether or not it was mold, asbestos, or this crystalline silica. It was determined to be crystalline silica, which is dangerous. All right, we know based on the defendant Soto's own admissions that he used concrete inside the home. What our expert is going to testify to is that you're not supposed to mix the concrete in the home. And what this individual was doing, and to be brief, you mix concrete outside of the home, and then you bring the mixed concrete into the home, and then you lay the concrete as needed, or the self-leveling floor mixture, whatever it may be. Here, what the defendant Soto did was he took the powder, the cement powder, put water onto the powder, and then threw it throughout the house, and he was laying it into the floor as he was doing it. A highly reckless standard, which our expert is going to say you're definitely not supposed to do that. Now, when they were throwing this powder, he was throwing it in front of a fan that was directed towards about 3 feet away from the HVAC unit. All right, this cement powder then went through the entire house. And that's what basically contaminated this house. And this is what caused the issues in my client, who was at the time, I believe, 76 years old, with, obviously, when you're 76, you might have some underlying ailments. She became symptomatic immediately following the defendant's work at the home, which resulted in this complete investigation. And then once it was determined that, yeah, this is dangerous crystalline silica, she was forced to leave the home. As a result of my client being forced to leave her home, she became severely depressed. She attempted suicide. And we have a neurological psychiatrist that has correlated major cognitive deficiency as a result of this depression of being forced to leave her home. And it's all very ordinary and natural for, once again, spreading poison throughout someone's home. So I think it's an ordinary consequence. I appreciate the argument that the defendant is making regarding Powell, but this isn't exactly a toxic tort case where my client, suffered some form of cancer as a result of the toxic tort exposure. As a result of the toxic tort exposure, my client was forced to leave her home, resulting in severe depression, not being able to live in her home. And basically the home has been unused for a number of years now.
Mr. Mooney.
Your Honor, even if we assume all of the complaints of the plaintiff to be true, there is simply no evidence at all that the exposure to silica caused the plaintiff's symptoms. There is no expert testimony. There is no treating doctor testimony on causation. Now, silica is used in this country all the time on a regular basis. There are standards set by OSHA and MyOSHA as to what a safe standard of exposure to these silicas is. There is no evidence at all in this case that Ms. Taylor was exposed to an unsafe level of silica. There is no evidence at all as to how long she was exposed to silica. There is no evidence at all tying the complaints of Ms. Taylor to any exposure to silica for one, and more importantly, to any particular product that Mr. Soto brought into the home.
Mr. Carl, one thing that hasn't been addressed, what's the product? What's the name of the product?
It's self-leveling floor mixture, Your Honor.
But okay, that's
the manufacturer. That's in the sole providence of the defendant. Plaintiff would not know that.
But have you done any discovery relative to that issue?
Yeah, and if we're dealing with, Your Honor, the defendant's agent who they hired to bring in my home is an undocumented immigrant who would not say what the brand was. I mean, regardless of the brand, it's still made out of the same stuff. And our expert's going to testify to that, basically it's all got this crystalline silica and you're not supposed to mix it in the home, regardless of the brand. It's basically, the difference in tissue. I mean, what's the difference in tissues, right? There's no difference in the manufacturing of tissues or, any other common product. It's not it's a fungible product. It's the same product, regardless of manufacturer.
Okay, what about the level of exposure?
Well, the level of exposure and the duration of the exposure, once again, my client's injuries resulted in her being forced to leave her home. When you find out that there is a dangerous, poisonous product in your home, what do? You don't
wait. You said dangerous, but silica is used in semen. It's not a dangerous product per se.
No, it is. It is. It's very dangerous when it's in particle form.
When it's
in a particle form. When it's in a particle form,
but that's what I'm saying. But the thing is, it's not a per se dangerous product, though.
No, it's definitely dangerous, and it's definitely not supposed to be handled inside a home, and it's definitely not supposed to be. It's per se dangerous. Crystalline silica, obviously, what the defendant is making regarding this argument are the particle size. He's talking about particle size. When you breathe in crystalline silica, it is dangerous. Period. I don't think there's any dispute of that. When you breathe it in, the dispute is whether or not my client was exposed to dangerous levels of it, and essentially which resulted in her symptoms. And my argument is that since this dangerous product was in her home, and we tested and we prove that it's in her home, and basically by taking a swab test and showing it that it was spread throughout the home, she was forced to leave her home, resulting in her depression. That's the heart of my client's damages, Your Honor.
Mr. Mooney.
Number one, Your Honor, again, there is no evidence at all that this silica came from any product that Mr. Soto brought into the home. And number two, if you extrapolate the circumstantial evidence, Mr. Soto's been working with silica for years. Obviously, safety. Mr. Soto is not sick. Mr. Soto is not claiming personal injury. There is a safe way to handle and to be exposed to silica. There is no evidence on our record at all that this was violated. There is no evidence at all that Mr. Soto and therefore Carpet Deluxe mishandled any products and that Ms. Taylor was exposed to any product that was mishandled by Mr. Soto.
Your Honor, I completely disagree with that. He mixed it inside the home. That's completely the wrong way to do it. In front of a fan, not just any fan, like one of those major industrial fans, 3 feet away, going into the HVAC unit. It's a small hallway. Basically, the fan was there to dry the concrete as he was spreading it by hand into my client's floor. And it just so happens that as he was spreading it by throwing the dust onto the floor, the fan was blowing into the HVAC unit. I mean, it's a havoc. And my client has not lived in their home as a result of this for the last 3 years.
Well, okay,
very
but
serious.
we're talking about, what are you saying? You've used the term of art that he sprayed this silica. I'm sure it wasn't just silica that he was.
No, it's a cement mixture, self-leveling floor mixture. They mix with water and it becomes hard.
And in terms of, I just, when I was looking at this, what we have here, Mr. Carl, it looks like it is a whole lot of circumstantial, unsubstantiated evidence. I just, because I was looking at this, and in terms of even looking at Powell and looking at Lowry, the two cases that you all have brought to the court's attention, the two pivotal cases, it's just interesting that, I don't know how the case law says that if you cannot produce sufficient evidence, substantial enough to address the issues of the dose, the exposure, and even look into causation and the damages, and the damages that you're talking about are the emotional distress, but there's no physical damages here. And just the emotional distress, I don't think that that's sufficient here. And what we've got is, we've got Powell, and then the court said in Powell that, if you rely on speculation, she can't identify what the product was, and for whatever reason you're saying she can't, then it's speculation. You just want to say that the silica was there, and we don't know what extent the silica was there and to what extent her exposure was. It's like the Powell case is controlling and the language is controlling, even though it reached a different result. The facts are there. I mean, not the facts. The position that was taken in in Powell. You have to look at the causation, the general and the specific causation. And it just wasn't, it doesn't appear that there's enough here to overcome that, to surpass being the grant of the summary disposition. And even in Lowry, and I know Mr. Mooney relied on Lowry initially, but just because, there was a spill, you say there was a toxin, you don't know exactly what it was. You're saying that it's the silica, but there's no proof. There's no causal connection with what you're saying. We don't have any information relative to the doses. And then the injuries you're relying on are emotional distress. There's no physical injuries here. So even as Mr. Mooney had indicated, we took the evidence in the light most favorable to the non-moving party relative to everything that the plaintiff articulates. And even doing so, the court doesn't find that this rises to the level of overcoming a motion for summary disposition. That being said, the court is going to grant the defendant's motion for summary disposition. Mr. Mooney, you can present an order to the court for entry and the court will sign the same. Then of course, Mr. Crawl, if you see fit, and if you want to go ahead and appeal it, I'd be interested to see what the Court of Appeals says. But I believe that the Court of Appeals and the Supreme Court have clearly articulated the positions relative to Powell that was as it was set forth, and as to Lowry as well.
Your Honor, two things. May I?
Yes.
I don't want to cut you off.
Go ahead.
I've made my record. All right. And you've made your ruling. Presumably, this would apply to defendant Soto, although
Yes.
defendant Soto did not file a motion for summary disposition.
Yes, the court is applying this to both defendants.
Okay. So the case is dismissed in its entirety with prejudice.
Yes,
correct,
and
Honor?
then this concludes the case, and Mr. Mooney is going to prepare an order and whatever relief, but like I said, I believe that the court has spoken through Powell and Lowry, and relative to the articulation that's been placed on the record by Mr. Mooney. You took the evidence in the light most favorable to the non-moving party relative to everything that was presented, and the court finds there is still a basis to grant the summary disposition. Okay.
Right.
And Mr. Mooney, I'll look for that order to be submitted to the court.
Thank you, Your Honor. Mr. Crail, I will prepare a very bare bones order and circulate it to you for your approval before I submit it to the court.
Certainly.
Okay, thank you both.
Next time.
Take care.